Boa noite, todos e todas aqui presentes. A gente vai dar início aqui ao 8º Congresso de Direitos Fundamentais e Processo Penal na Era Digital, organizado pelo InternetLab aqui na Faculdade. Eu tenho o privilégio, assim, a honra e a alegria de ser a coordenadora, acho que desde a primeira edição do Congresso, e é realmente, assim, sem falar muito do passado, mas eu acho que quando isso começou, e o InternetLab faz 10 anos agora, acabou de fazer, acho que a gente não poderia imaginar que seria um congresso tão longevo, tão presente, né, na agenda de quem se dedica aos temas de intersecção de processo penal e tecnologia. Então, é um privilégio ter sido escolhido pelo InternetLab para sediar aqui o evento mais um ano e dizer da importância do material que é produzido aqui, das discussões que são travadas aqui nesses dias, o quanto que depois os anais, e acabam, né, de ser publicado mais uma edição, servem de discussões aqui na faculdade. Eu vejo vários alunos aqui da pós-graduação que podem, e da graduação que podem atestar o quanto o InternetLab contribui para essa discussão, não só no ambiente forense, na sua atividade junto aos tribunais, funcionando como amicus curiae e tudo mais, mas também na discussão acadêmica sobre vários pontos. E eu queria, antes de passar a palavra aqui ao Chico, ao Francisco Cruz, que é o diretor do InternetLab, dizer publicamente, assim, da minha felicidade, que foi, nessa edição, trabalhar ao lado do Ivan, que também é mestre aqui pela faculdade, do André, que é do InternetLab, contar no finzinho com a ajuda da nossa atividade de extensão, que foi reorganizada esse ano, o NDIS, que é muito importante aqui para a faculdade como uma atividade extensionista, com a colaboração da Helena, de outros mestrandos que têm trabalhado também nesse assunto. Então, sem mais delongas, porque a professora já nos aguarda ali, eu passo a palavra ao Chico. Obrigada.
Olá, boa noite, tudo bem? Bom, como a Marta disse, eu sou o Francisco Brito Cruz, Chico, eu sou o diretor executivo do InternetLab, e, enfim, venho aqui para... Não quero repetir muitas palavras da professora Marta, a alegria enorme que a gente tem de estar aqui mais um ano na faculdade. O congresso esse ano ele mudou de data, né? Eu vou até explicar porque ele mudou de data, porque acho que tem um motivo especial para ele ter mudado de data. Ele geralmente acontecia em agosto, né? Agora a gente colocou para novembro. A gente colocou para novembro porque justamente em agosto a gente tinha as festividades de 10 anos de InternetLab. E ia ser um pouco uma sobrecarga a gente juntar todas as coisas no mesmo mês. E estou dizendo isso porque nesses 10 anos de InternetLab, o Congresso, acho que é o evento, para além de ser o evento mais recorrente, né, mas é o evento que a gente mais observa como ele foi, como disse a professora Marta, né, ele foi criando relevância, mas foi criando impacto também, né. As obras que a gente publica após cada congresso, né, a obra que está aqui é do congresso do ano passado, né, a gente compila o que nossos palestrantes, as nossas palestrantes falam, e publica uma obra no ano seguinte. Essa obra ela é distribuída para uma série de, enfim, figuras do meio jurídico que já participaram do congresso, por exemplo, ou também enviada para tomadores de decisão que trabalham com esses temas, né, além de estar disponível na internet para qualquer pessoa. E a ideia com isso é que a gente consiga transformar as discussões daqui em algo que consiga ser utilizado, né, no dia a dia dos operadores do direito, das operadoras do direito, que trabalham nesses temas. E eu acho que, sem sombra de dúvida, isso transformou o Congresso numa verdadeira empreitada do InternetLab nesses temas, e que nos orgulha muito, assim. É uma empreitada bom, 8 anos, né, de Congresso, 8 anos que a gente já tem produção sobre esse assunto, né, e sobre todas as ramificações desse assunto, né. Esse ano eu acho que faz sentido, como sempre, agradecer no começo e no final do Congresso para a equipe do InternetLab que trabalhou firme nisso, João, pela nossa comunicação, o André, que é nosso coordenador de pesquisa, que, enfim, se dedicou muitíssimo para o Congresso sair do papel, todo o pessoal que está lá fora, na nossa mesa de credenciamento, vejo aqui o Vitor, também da nossa equipe, a Dani estava por aí. Então, assim, queria agradecer a todo mundo de verdade que fez o Congresso sair do papel. Para nós é algo muito importante ter a equipe engajada nisso. E aí também um agradecimento muito especial para o Ivan, professor Ivan De Franco, que nesse ano ocupou uma função que não existia nos anos anteriores, né? A gente aproximou o Ivan como consultor acadêmico nesse momento do Congresso para nos ajudar também a pensar no programa do Congresso, pensar nessa organização e fazer com que ela fosse, de fato, uma programação e um jeito de fazer que se encaixasse também no dia a dia do processo penal, né? Então, o Ivan, enfim, deu show para o Congresso ser organizado da forma como ele foi, como ele está sendo aberto aqui. Então, um agradecimento muito sincero a ele também. E sem mais delongas, eu vou apresentar a nossa Keynote Speaker de hoje, né? Então, vai fazer essa palestra de abertura do Congresso. A forma como vai funcionar, a gente vai ter a palestra da professora Fionnuala por, André, quantos minutos? Vai falar por mais ou menos 30, 40 minutos, depois a gente vai ter espaço para perguntas, respostas dela, então vamos ficar aqui num debate por volta de uma hora e meia, né? E depois a gente vai para o nosso coquetel de abertura do Congresso, que vai ser na Sala Visconde São Leopoldo, né? Então, atravessando aqui o hall que tem as escadas, do outro lado, né? Que é a sala do museu da Faculdade, para a gente poder comemorar junto mais um ano desses 8 anos de Congresso. Bom, a professora Fionnuala Aoláin, e aí ela me corrige se eu pronunciei errado ou corretamente o nome dela. Além de ser professora regente na Universidade de Minnesota, né, diretora do Centro de Direitos Humanos dessa Faculdade de Direito, também professora de Direito da Queen's University de Belfast. Em 2017, né, a professora foi nomeada pelo Conselho de Direitos Humanos das Nações Unidas como relatora especial para a promoção e proteção dos direitos humanos e das liberdades fundamentais na luta contra o terrorismo, né? Então, nessa qualidade, trabalhou em colaboração com estados nacionais, com organizações internacionais, para promover a proteção dos direitos humanos nesses contextos extremamente difíceis, né, na luta contra o terrorismo. Ela foi reeleita pelos estados para um novo mandato de 3 anos em 2020, e seu mandato terminou em 2023. E aí ela foi eleita para a Comissão Internacional de Direitos em 2023. Então a experiência da professora Fionnuala é bastante rica, né, no enfrentamento dessas realidades, sempre olhando para a proteção de direitos fundamentais, é o que nos faz abrir o Congresso desse ano. Agradeço a presença dela, passo a palavra para a gente começar os nossos trabalhos.
Thank you, everyone. I am really pleased to join you today, and I'm really sorry that I'm not able to be in Brazil in person. It's much warmer in Brazil than it is in Minneapolis, in the middle of the United States. But this is the Thanksgiving holiday in the United States, so I am home with my family for a break. I'm also really pleased to address this topic of spyware regulation, as it's been a topic of significant interest to me, not just as an academic, but during my time as UN Special Rapporteur on Counterterrorism and Human Rights. In general, this area of new technologies and their interface with rights was of enormous importance in my term. And it also feels really important and urgent and relevant to be with you today, as the Brazilian Supreme Court is about to rule on a case concerning the use of spyware technology for criminal investigation. So your move from August to now was probably well-timed for other reasons as well. The pending Supreme Court action in the United States, in Brazil, is one that is focused on the violation of constitutional rights by virtue of the use of this kind of surveillance technology, the use of remote virtual intrusion technologies. And it does seem to me that the country, Brazil, has an enormous and powerful moment to address as a constitutional matter the legality of the use of these kinds of digital intrusion programs and their use on all our communication devices, from our cell phones to our tablets to our electronic devices. And I think in particular, precisely because the Brazilian Constitution has a provision on protection of data privacy and data as a constitutional norm, which is extraordinary and quite unusual as a global matter, there is this really important moment for Brazil in some ways to lead a global conversation on the lawfulness as well as the human rights compliance or compatibility of these kinds of technologies. I also want to acknowledge the value and the sophistication of the amicus brief, which was submitted by InternetLab and Data Privacy Brazil to the Supreme Court. It's just an exceptional piece of work. And not only, I hope, will it inform thinking of the Supreme Court, but it's the way that that argument is structured, I think, is an exemplar of the kinds of arguments that need to be made in other parts of the world about the use of these technologies. So let me start by saying what we know about the harm of spyware. Since the worldwide media investigation into the leaked list of targets of Pegasus spyware technology, none of us, Brazil, Ireland, where I'm from, the US, where I live, none of us can ignore the excesses that we see of the state use of covert digital surveillance tool to spy upon ordinary civilians, but also to spy on politicians, journalists, human rights activists, lawyers, and honestly, people who just have no connection with any kind of criminality or terrorism or security. These issues, I know, are also ripe in Brazil. You have an ongoing investigation about the use of these kinds of technologies against opposition figures in your country, which tells us the dangers in democracies of the use and the availability of these kinds of tools. These tools are manufactured in lots of places, in the United States, in the EU, in China, in Israel, and in the UAE. And I think it's important that everybody understand how powerful these tools are. Not only do these tools, these surveillance tools, allow access to your communications on your phone or your tablet, they also give access to your contacts, to your geolocation, where you are, where you've been. They give access to metadata. So nothing is secret from these tools. They give access to the entirety, effectively, of your life, to the state or the party that accesses and uses them. But more than the fact that they allow access, they also allow the user to delete information, so they can take information off your phone. You will never know that it's been taken. They can plant incriminating information, so they can put things on your phone or your tablet. And everything that's done can be hidden. So part of the problem is the access, the taking, and the changing of information can all be done without ever being known to you or even afterwards to investigators. So the truth is that we don't know how much spyware is being used globally, but clearly it's enormous. Last year, the PEGA committee, a committee before the European Parliament, which was investigating the use of Pegasus, the tool that is, it's an Israeli company that uses this tool, and revealed that about 12,000 people a year were being targeted by Pegasus alone. So that's a lot of people in a lot of countries. So with that background, I want to talk about four things. I want to talk a little bit more about the actual technology so we understand the technology a little better. I want to talk about the human rights and rule of law concerns about the sale, use, and transfer of commercial spyware by states. I want to then, third, talk about regulation and oversight. And finally, I want to reflect, particularly because I think it's so important to Brazil, to reflect on the value of robust judicial oversight allied with strong national and international regulation. Okay. So let's talk about the technology. What is the technology? Everybody has a smartphone or a phone that can do lots of things. And I wanted to quote from a human rights defender I interviewed some years ago who said they were talking about their fear of spyware. And what they said was the following, quote, "This is more than eavesdropping. It's terrifying. The spyware takes complete control over the phone. It can make calls to anybody. It can send messages to anybody. It can download content. Whoever is operating the surveillance equipment could phone someone in ISIS and say that I have been phoning ISIS. And no one might believe me that I did not do these things with my phone," end quote. So this powerful, powerful technology is not just one version. There are different versions of spyware. But part of the problem of spyware for us lawyers and even for tech people is that the production and use and sale of this technology is covert. It's hidden. And so actually we have a very poor understanding in many ways of the scale, scope, and even the technology itself. But what do we know? Well, we know first, the tools can gain access to your computer, to your mobile phone. And sometimes what's really important is that this technology happens with what we call zero click. You don't have to click something to get it. So it can come into your phone or your computer without you knowing it. Second, once your device is infected, the operator, so whether that's a state agency or someone outside your state, can actually access everything. They can record video, audio, text. They can access your email, and even things like secure platforms, things like WhatsApp and other platforms that have encryption are not safe from spyware. So even the technology we have to protect us is not protecting us. The third thing I would say is that it's not just that the spyware infects your phone, but every other connected device you have to your phone is also accessible. So for those of you who wear watches on your hands that say you have a heart condition, or you have been exercising, or that you have to watch your sugar intake because you're a diabetic, all of that information will go to the person or the entity that's surveying you. The most intimate personal information of our lives is sucked up by this process. And most finally, the thing that I think as lawyers we should worry about the most is that spyware technology grants not just this monitoring process that you monitor what someone is doing, but actually it allows the user, the operator, to manipulate your data. And for us as lawyers, that should send big red lights flashing, because it tells us that actually the integrity of information, which is central to legal process and to criminal procedure, the integrity of those procedures are fundamentally threatened by this technology. I should say, as I said, there are many, many firms producing this technology. They are all over the world, from Italy to the UK, from France to Israel, from North Macedonia to Hungary. We have the US and the UAE. So this is a multi-million-dollar global industry. And so countries like Brazil, my own country, Ireland, we are at a huge disadvantage when we face the power and might of these firms from across the globe who are selling their wares to governments who want to buy them and governments who are not concerned about the human rights challenges. The other thing I want to say, and then I'm going to talk about the human rights piece of this, is that I'm focused today on spyware technology and commercial spyware technology, but there are a whole host of other adjacent technologies to spyware that should also worry us as lawyers. Things like hackers for hire, SS7 exploitation, sphere phishing, massive intercept, commercially used tools, infrastructure abuse. There's a long list of things that we have to worry about in terms of their impact on privacy, on rights, on legal process, on human dignity, on the rule of law. But let's start where we can start. I think if we start thinking about regulating spyware and being robust in our regulation of spyware, we have a way to get to these other technologies that are really problematic. So I see the regulation of spyware as a way to do this big work we need to do on surveillance. So let me talk a bit about my second point. That's the technology. That's how it works. Let me now talk about the human rights implications that arise from spyware. And so I want to say the obvious, that spyware and these intrusive digital tools are vulnerable to and implicated in serious, profound human rights violations. And when the Supreme Court considers the use of spyware in the context of Brazil, it's my strong view that the court should be aware of the scale of misuse of this technology in other countries and seek to protect Brazil from the same kind of challenges. So let's start with the right to life. We have seen many connections between violations of the right to life and the targets of spyware. And the reason for that is, I think, quite simple. Spyware allows repressive regimes, or just even not so good regimes, who don't like their opposition, who would like to minimize the people who criticize them. Spyware allows those regimes to identify dissidents and specifically to identify their movements through accessing their private communications. It can pinpoint geolocation and real-time monitoring, and it can allow for fail-safe targeting. It means that the state knows where you are all the time. And as the special rapporteur on summary arbitrary executions identified, it was exactly the use of this spyware in this way that pinpointed the movements of journalists and communications of Jamal Khashoggi. And it was the fact that the spyware told the assassins where he was that allowed him to be killed. So a direct relationship between the spyware and the violation of the right to life. The second set of violations of non-derogable rights I want to highlight are violations of personal security, freedom from torture, and freedom from unlawful arrest. In countries like Bahrain, Egypt, and Saudi Arabia, we have, through DigitalLab in Toronto and the Amnesty Lab in Berlin, we have identified a direct and credible link in forensic digital analysis that demonstrate that people were targeted and located for arrest, torture, and taking away their right of personal movement because they were able to be identified through the geolocation and other information on spyware. The third violations I want to stress are gender violations. I think it's really important to understand that spyware has been used to target women in very specific ways. And that's because spyware allows access to private information, and it's particularly ripe for abuse that affects women when authorities can weaponize personal information through campaigns of gender-based defamation, blackmail, often through threatened publication of private imaging, and personal information about one's sexual life, and doxing. The fourth right I want to focus on is privacy. And I think it's really important, as the court must do in the case before it, to focus on the centrality of privacy to human dignity. It's fair to say that previous forms of surveillance have tended to threaten privacy because they're too broad, like they're just big. So I think of bulk internet communications or bulk surveillance. These target lots and lots and lots of people in a wide and big way. But I want to suggest that the threat posed by spyware is different due to the targeted nature of the technology. So despite the fact that it's targeted specifically at one or at individuals, spyware technology allows harvesting of all information about a person and all of their contacts and communications. So if we think about this from a classic criminal law perspective, you want to target one person for criminal investigation, and the state authority will argue for the right to target one person. But the very nature of spyware, it's built into spyware, is that you're not just targeting one person, you're targeting every single person that that person is connected to on their phone. So it's by nature indiscriminate. It's by nature overbroad. And so to me, one of the major challenges from an authorization or legality perspective here is that spyware will go far beyond what is necessary for investigation and will, by virtue of its design, violate the principles of necessity and proportionality, which the Constitution of Brazil and many others and many international treaties require. The other thing I want to stress is that as we think about the harms of surveillance technology, we must, in my view, fundamentally rethink the importance of privacy in the scheme of human rights protection. I have often characterized privacy as a gateway right. What do I mean by that? A gateway right is a right that enables other rights. Without the right to privacy, we don't have a right to life. Without a right to privacy, we don't have rights of personal freedom. Without privacy, we have none of these other rights. And to me, because privacy enables other rights, we have to give, particularly in the digital age, courts, and I hope the Brazilian Supreme Court will understand that privacy must be an elevated right in the digital age. Privacy is required in order to safeguard the individual fundamentally in a technologically evolving society. And while many of us know that people are ready to give away privacy, so I see probably some students in the room who are on WhatsApp and Twitter and all of these other things, and we give away a lot of our privacy every day. But when we do that, I think courts have a role to play in reconstructing and revalidating the right to privacy as central to our collective protection from serious human rights violations. And when privacy is a derogable right and it's a limitable right, but it is my view that both national and international courts must repurpose their approach to addressing violations of privacy. They must specifically limit what we call in the European system the right to the margin of appreciation, and they have to use a strict necessity test under international human rights law if they are to limit the right to privacy. Two other rights briefly I'm going to talk about. One is interference. Spyware interferes with freedoms of expression, association, and assembly. The prevalence of the use of spyware technology in repressive states creates interference with rights, because the knowledge of surveillance that you have leads to self-censorship. And I think this is a particularly fraught issue for Brazil. In recent years, Brazil has bought a whole lot of biometric data technology during the COVID period. There are already huge concerns, I think, in Brazil about the scale of surveillance in public spaces, including through the digital city network and strong cities. And so again, I would stress that when you layer in already what is monitored in the public space in Brazil, and you add in spyware technology, I think it poses some, it's not the singular issue of spyware, but it's spyware added to existing biometric plus facial recognition technology in Brazil. Finally, let me just stress for lawyers that spyware, as I've said, interferes with the integrity of documentary records and evidence. It undermines procedural fairness and the rule of law, precisely because it allows for the manipulation of communication and records. And so spyware allows for unscrupulous users to forge evidence in order to incriminate or blackmail targets, to delete records and not to have evidence. This potentially has catastrophic impact on fair trial and due process rights, casting doubt on evidence that's used against individuals, and I think could allow for the systematic undermining of criminal investigations. So those are the harms, and I do want to stress that I think in particular the harms are on the scale of individual rights, but I also want to stress that the harm of spyware and these kinds of intrusive technologies are also particularly felt by civil society. In 2023, I issued a global study as UN Special Rapporteur on the impact of security, counterterrorism, and preventing and countering violent extremism on civic space. And in region after region, including in Latin America, what I learned is that many civil society actors are cowed, they're afraid, they're self-censoring, and they're deeply concerned about the impact of new technology and surveillance on their capacity to do what they do and are protected by international law in doing. And so again, as the Brazilian Supreme Court weighs the use of this technology, looking at the experience of other societies, and in particular, the global and documented harm of spyware on civil society is important. Okay. The third issue I'm going to talk about is oversight and regulation. And I'm going to stress how important it is that we need regulation and robust judicial oversight of spyware. And the reason we need that is because of the scope, depth, and scale of harm surveillance technologies can cause. And the other reason we need it, and I took note of the arguments that are being made by the state in the Supreme Court decision of why the state needs this technology. And the arguments that are often made in this space are what I call blinkered security thinking. It's a way of thinking about security that has a really restrictive approach to rights. Now, I do not doubt that there are serious security threats, and they include organized criminality, and they include terrorism, and they include security around the globe and in Brazil. But if we only look at these problems through narrow security lenses, and we don't accept the broader context in which these problems are emerging, as well as failing to understand the problems that accompany security fixes like surveillance on these problems, we miss some things. And so one of the things we have to be very careful of is the high-profile justification of exceptional measures like surveillance that tend to push out the techniques that have been used for decades by the state to address serious problems. What the problem when we use exceptional measures like security surveillance is that, as many of us know, and I notice in Brazil, your equivalent of GDPR, of data oversight, has specific exemptions for national security. And so the challenge that you face is that when an argument is made to use surveillance because there's an exceptional problem like criminality, we then get a tool that is subject to less review and less oversight and has more carve-outs than the ordinary law. And the result of that is, even in a country like Brazil, that has in fact very good oversight regimes, like an oversight mechanism on data protection, there are these security carve-outs that are kind of hardwired in. And so the danger of allowing for an exceptionality argument is it's not just exceptionality on the tool, but it's exceptionality at the back end, that there's less oversight, less accountability, less transparency, and less scrutiny of the tool. The second point I would make is that often, as I've said, the enthusiasm for this new technology like surveillance technology is because everyone thinks it's a quick fix. It's an easy fix. It's going to solve, it's like a silver bullet to solve a problem. And I want to suggest that that's just not true. That global evidence tells us that when you rush to adopt new technologies without rigor prior analysis of whether these technologies will jeopardize human rights, the rule of law, and equality, then you have these back-end problems where the technology is not a fix at all. In fact, it just creates new problems. So my final comment is really, what would oversight look like? And in 2023, I issued a position paper on the global regulation of spyware technology. And I've set out for the globe, but also for national systems, what a fundamental human rights compliant approach to the regulation of spyware would look like. This is a challenge for every country, but it's also a challenge for Brazil. And I want to suggest that Brazil is better placed than most countries to do this work. You have an amendment to your constitution in 2022, which expressly includes personal data and digital media. In 2020, you established a general data protection law, which came into force, which is very similar to the GDPR in Europe. And you have a national oversight agency, the ANPD, Brazil's National Data Protection Authority. So I want to suggest to you that Brazil is actually in much better shape than lots of countries I work with and have visited. Now, these structures are not perfect. They have national security carve-outs, but they do seem to me to provide a really robust basis for Brazil to be a regional leader on the question of oversight of data protection, but also preventing and holding surveillance technology accountable. And married to that is the role of the Supreme Court. The fact that a Supreme Court is considering this question in a rights-based framework is quite extraordinary. And I think your Supreme Court has this extraordinary opportunity to do something that will be not just important for rights protection in Brazil, but will have a ripple effect across the globe and the region. So let me close by saying that beyond the Supreme Court, we need specific national and international regulation on spyware. We need to make sure that the actual construction of spyware itself, the tools, has to have certain key features that prevent things like automatically accessing data related to the contacts of individuals, flagging when there's any change to data on a person's phone, and more than anything else, if spyware is used, that there is an indelible, permanent, and uneditable record of the misuse by the state agency. And my report says more. But let me close by saying that I think precisely because of the fertile terrain in the national context in Brazil, that this role that you can play at this time is critical. Spyware remains a pernicious, dangerous tool And it is a tool that poses an existential threat, in my view, to the health of democracies and the health of the rule of law. And so it's extraordinarily fortuitous that we have this opportunity to talk about it today. Thank you very much.
Obrigado, professora. Acho que foi uma exposição bastante clara e que abordou uma série de pontos, inclusive conectando eles com nossa realidade, né? Bom, a gente vai agora para perguntas. Vamos fazer blocos de perguntas. As perguntas podem ser feitas em português, que aí serão traduzidas para a professora. Da última vez, só confirmando, a gente pede para que a pessoa venha até aqui para fazer a pergunta no microfone, senão não vai para a tradução e aí ela não consegue entender. Então, fazer blocos de 3 perguntas, né? Talvez 2 blocos, dado o tempo. E, enfim, quem quiser fazer uma pergunta pode levantar a mão. Por enquanto. O Ivan vai quebrar o gelo para a gente, mas fiquem à vontade. Vai levantando a mão também, eu vou olhando e aqui puxando para quem quiser fazer pergunta. Ivan, por favor. Acho que é importante se apresentar na hora que for fazer a pergunta, né, para a professora saber de onde vem.
Bom, boa noite, professora, que é o Ivan, e queria agradecer novamente a senhora por estar aqui com a gente hoje, não só por ter feito essa palestra, que é muito interessante, tema super atual e importante, mas também por ter estado disponível para estar aqui com a gente no meio do seu feriado do Thanksgiving, que a gente sabe que é muito importante nos Estados Unidos. Então, obrigado por isso e também por ter se interessado e se aprofundado no estudo do Brasil, da decisão, da discussão que está sendo posta no Supremo Tribunal Federal, na nossa Suprema Corte aqui. Isso também foi muito interessante, enriqueceu bastante para a gente, para os brasileiros, ouvindo a senhora falar. Então, obrigado por isso. Sobre a pergunta, é uma pergunta, mas que, na verdade, talvez sejam algumas que eu queria colocar. A senhora mencionou, quando falou, principalmente no primeiro e no segundo blocos, sobre as principais dificuldades, né? Enfim, descrevendo um pouco dos spywares e depois demonstrando quais seriam os perigos para a efetivação dos direitos humanos. A senhora mencionou o Pegasus. Aqui no Brasil, a gente teve um outro tipo de spyware que está sendo, inclusive, investigado por ter sido usado contra opositores políticos, jornalistas, etc., que foi o First Mile, mas a discussão é bastante semelhante. E o tipo de dano causado também é bastante semelhante, domesticamente falando, né? E quando a senhora fala que vê com enfim, um otimismo, com uma grande possibilidade, o julgamento do Supremo, me causou bastante curiosidade, porque eu, estudando o tema, enfim, lendo inclusive o seu relatório para a gente trabalhar no nosso Amicus Curiae, o que a senhora fala nos 2 primeiros blocos da sua exposição demonstra uma dificuldade muito grande de se regular algo que intrinsecamente é problemático, né? Me parece difícil regular algo com uma capacidade de intrusão tão grande na vida privada das pessoas. Mas, enfim, até no relatório que a senhora lidera e apresenta, existem formas de se regular, de pelo menos tentar minimizar os danos causados pelos spywares. Mas, enfim, é algo que eu queria ouvir da senhora. E, assim, o relatório foi publicado em abril de 2023, pelo que eu me lembro. Eu queria saber da senhora se teve a oportunidade de ver algum tipo de evolução, seja em nível nacional, em algum outro país, em termos de regulação ou de banimento, que a senhora, inclusive, sugere no relatório que poderia ser uma das consequências a partir de uma análise sobre os spywares, e também internacional. Daí, finalmente, concluo a minha pergunta, porque talvez a forma mais efetiva de se regular, se é que é possível regular os spywares, seria por meio de uma regulação internacional e vinculante, né? Porque se apenas um país, no caso o Brasil, ainda que tenha uma liderança relevante regional, fizesse uma regulação desse tipo de mecanismo intrusivo, a gente ficaria, de alguma forma, de mãos atadas, porque são tecnologias estrangeiras e que o país possivelmente teria uma pouca margem de manobra para, enfim, influenciar na forma como essa tecnologia é produzida. Então, enfim, essas são as ponderações que eu queria fazer, e de novo agradecendo a senhora pelo seu tempo.
Antes de passar para a professora, eu pergunto se alguém da plateia quer emendar alguma pergunta. Por enquanto não, estamos tímidas. Então, professora, a primeira pergunta, peço para...
They're shy, and there's also there's a cocktail party waiting, so those two things could go together. Let me say, I just want to say I appreciate, your comment, Ivan, about the use of Pegasus-like technology in Brazil. I think really raises some very problematic question. We know that my understanding is that there are 21 search and seizure warrants outstanding against individuals who were suspected of conducting surveillance on political opponents. And I think I also understand, at least in what's available to me in the US, that the federal police have identified that there was kind of a structure within a structure, which was utilizing resources for what was termed illicit actions, mainly using geolocation tools without authorization and interfering with the regular conduct of the police. But it speaks to the danger of the unregulated access to these tools, right? That the absence of a strict legal framework leaves abuse possible. And Brazil has had it. We've seen it in Poland. We've seen it in Spain. We've seen it in multiple countries. So your question is, so there are really three options on the table for spyware regulation. One is to ban it completely. And the former UN Special Rapporteur on Freedom of Expression, David Kay, a close friend and colleague, has argued strongly for a ban. The second option is a moratorium, so just stop use now until we figure out how to fix the technology. And the former High Commissioner for Human Rights, Michelle Bachelet, took that position. And in fact, several countries led by Costa Rica in the region have argued for a moratorium. So in my heart, I wish for a ban, and I would be okay with the moratorium. But I'm quite pragmatic, and my pragmatism tells me that right now, so many countries have access to this technology and are using it, that maybe we've missed this window to ban it. And I think that's a question. A little bit like drones, in the early years of drone technology, we thought we could ban it, and we didn't. And now we have whole conflicts like Ukraine that are, drones are leading the fight. So I feel like we have to make the case. If we could get one country to ban, we would be in a great place. But I think this depends a lot on political leadership at the domestic level and strong civil society action who understand the harm of the technology. But if we don't get a ban and we don't get a moratorium, then I think we're in the space of regulation. And I think it's design. We actually have to start at the way the technology is made. And as I said, it has to have these features that have to be built into it. That if you use it, that there's a record, that you have to avoid, there has to be a built-in structure to avoid automatically accessing data that relate to other people, not just the contacted individual. And that you have to have some way of targeting data, not just capturing everything. Now, it's my view that may be possible, but I also know there is technologically, it's not clear that these companies want to produce that kind of thing. Like, this is a lawyer saying this is how you could do it, but it's not clear this is what states and private companies want to do. Where do we see good practice? Well, I give two examples of good practice. One is during his tenure, President Biden of the United States issued 2 executive orders banning the use of spyware by federal agencies in the United States. So a domestic executive order, which has limited the use of spyware in the US. It remains an open question if that will survive the next presidency, but that was one very positive effort. And the second, I think, is the PEGA committee report, which has spawned national investigations in Spain and in Poland. And to be frank, the next thing we need European regulation on spyware. That would be the next big move on this chess table, I think. Over.
Obrigado, professora. Mais perguntas? Por favor.
Olá, professora, obrigada pela palestra. Legal. Oi, eu sou Vitória, eu sou doutora daqui da Faculdade de Direito da USP também. Eu queria te perguntar se, pensando em casos como a explosão de pages em Israel, como você acha que impacta a confiança das pessoas no uso dessas tecnologias? Quais são os impactos dessas quebras de confiança?
Mais perguntas? Acho que a gente está tendo menos. Pedro, por favor. Só mais uma pergunta, professora. A gente já passa.
Professora, boa noite. Primeiramente, agradecer pela palestra, foi extremamente elucidativa. Eu sei que a minha pergunta talvez soe como uma pergunta de $1 milhão e entre um pouco nos limites da imaginação, mas a senhora comentou que, enfim, essas tecnologias poderiam ser consideradas não proporcionais por não respeitarem os requisitos da proporcionalidade e da necessidade. O que eu gostaria de saber é como a senhora imagina que poderiam surgir tecnologias menos invasivas que poderiam combater, né, essa nova criminalidade no mundo digital.
Mais alguma pergunta? Não? Professora, por favor.
So great questions. So I think the first question really talked about who is producing the spyware. That's a really important question. What are these lists of countries? And do we in fact trust that the countries producing them are capable of regulation, right? And so one of the things that really concerns me is the who's who of production, because many of these countries are not rule of law compliant states. They're states in breach of international law. They're states who are repressive and authoritarian. They're states who've developed these technologies because they want to produce an apparatus of control over others. And so it's certainly clear that the development of spyware technology in Israel came from security apparatus, a theology of security, which is largely addressed to the Palestinian population of the occupied Palestinian territory and Gaza. So the laboratory for this kind of technology has often been internal repression in these states. And so I think that's a really great question about if we even produce a global system, do we genuinely trust that these states can enforce it? In other states, for example, the US and the Europeans are producing a lot of spyware. And there, I think it's not perfect. But at least, for example, in the European context, we have the Wassenaar dual use system, which I know Brazil is not a member of that system, and the dual use and export control system. And I think in that context, we do have some frameworks that help us control. So the answer is, I don't think it's going to be perfect. I don't think any regulatory system will be perfect. And we will still have states who are outside and bad actors. but then it's really clear that they're bad actors because we have rules that prevent them, that they shouldn't be doing, and then we can name their violations more clearly. So I'm not a big believer that we can get perfect systems, but I think a good enough system that would limit the misuse of spyware sale, transfer, and use, that would be a good start, I think. Let me answer the question on, are there other technologies that are better? Well, I think one of the things that we're seeing is, of course, states, and this is, we live in the digital age, and states want fast solutions and they want shiny technological solutions. And those are increasingly going to be harnessed to the AI capacity of states. So it's not just that they're collecting data, but they can move through large amounts of data faster and more efficiently. And so I think one of the almost counterintuitive moves here is that you're asking the state to slow down. You're asking the state to rely on existing systems, which they and members of the public view as inefficient. And you're asking states to turn away from things that look bright and shiny and available. And I think that's a really hard political move to make. I would say we have plenty of evidence that these older systems often work fine. And I'm not a defender of the status quo for the status quo's sake, but it's recognizing that the cost of these kinds of tools have enormous consequence for the integrity of rights-bearing systems. So you're trading off benefits in this space. And maybe I would say that, we've seen courts and legal systems manage things like e-evidence well. In the field that I work in, we've seen developments in things like battlefield evidence, which is the bringing in of new kinds of evidence into particularly the management of war crimes and core crimes under international law. So it's not an attempt to remain in the Stone Age of investigation, but it is actually a push against saying that we have to adopt at speed these technologies and their use in our criminal justice systems when we have not put in place systems to manage them and oversight of their abuses over.
Mais perguntas? Temos mais três perguntas. Então, primeiro ele, depois ela, depois ele, tá bom? Temos mais 3 perguntas, professora.
Professora, boa noite. Primeiro, gostaria de agradecer pela palestra. A minha pergunta é basicamente se seria uma forma efetiva de regulamentação do uso de spyware impedir que empresas ou entes particulares desenvolvessem esses mecanismos e que eles fossem criados especificamente apenas dentro da estrutura estatal, sob o ponto de vista de também oversight político, que isso poderia possibilitar que elas fossem desenvolvidas tendo em vista também objetivos de proteção de direitos fundamentais, ou se tendo em vista que é justamente o Estado quem geralmente usa essas ferramentas para lesar direitos fundamentais, se esse tipo de proibição seria inócua ou até mesmo pioraria a situação atual.
Mais 2 perguntas?
Oi, professora, muito obrigada pelas palavras até agora. A minha dúvida, ela é muito mais voltada para o indivíduo, para o usuário, né? Quando a gente fala sobre spyware, a gente pensa também na questão política e como que o governo e toda a articulação em volta vai poder fazer as suas manobras tanto para legalizar ou então para proteger o direito dos indivíduos à internet, quando a gente fala de spywares. Mas pensando numa regulação, independente de que seja a LGPD ou alguma outra lei de proteção de dados, independente de qual país seja, você vê a viabilidade do indivíduo saber que ele está sendo investigado. Parece uma resposta óbvia, né? Parece que sim, ele deveria saber, mas qual que é a viabilidade disso? Você pensa que, uma vez legalizado, ele tem que saber, ele tem o direito de saber que os seus dados estão sendo utilizados para alguma coisa? Muito obrigada.
E vamos para a última pergunta desse bloco.
Olá, professora, boa noite. Meu nome é André. A opção de utilização desses mecanismos será uma decisão política e claramente depende de um conhecimento preciso da tecnologia. Na visão da professora, considerando que se trata de tecnologias privadas, quais seriam as bases para uma regulamentação internacional, especialmente em relação à cooperação tecnológica, que não afetasse outros direitos como o direito de propriedade intelectual? Isso porque o não conhecimento das features, né, da própria tecnologia, pode impedir o conhecimento, uma regulação total. Muito obrigado.
Professora?
Thank you. I think I might have missed a little bit of the first question, so let me start with the second, go to the third, and then I might ask the translator to just give me a synopsis of the first question again. So on the second question is about users and whether it's feasible for an individual to know that they are the subject of this kind of surveillance. And I would say that this is one of the fundamental debates among governments who use any form of surveillance. And so, as special rapporteur, I had the, I suppose, privilege or opportunity to spend a lot of time with intelligence agencies. And in some intelligence agencies in liberal democracies, there's a meaningful debate about whether or not and at what point a person should know that they are the subject of surveillance, that they have that right as a legal matter. And if that surveillance ends and nothing has happened, meaning surveillance has started and then there's no legal proceeding that follows it, whether a person has a right to know, right? Do we have a right to know, a right to truth, as it were, as to what our governments have learned about us? And from a human rights perspective, my mandate when I held it and my predecessors made the argument that the individual has a right to know. Now, there may be some staging of that right, meaning if you are in an active criminal investigation, let's assume you're tailing somebody old-fashioned way, then you're not going to tell them that immediately, but that there is a point that crystallizes when a person has a right to that information. But I will say that there's no consensus on that point among governments. So human rights actors believe in that right as part of the right to know what relationship, what the state knows about you. But states don't agree that that's necessarily the case. And for sure, intelligence agencies have strong views on whether that they should know. Now, increasingly, many of us are finding ways to have our phones checked. We're now depending on the state telling us. And so across, including in Latin America and across the world, we're seeing the development of what we call threat or forensic labs, where you can take your phone in and get your phone checked to see if it has been surveyed by the state. So what I see happening is individuals aren't depending on the state to tell them. They're taking action and learning, and civil society is learning how to figure out if your phone is being used. But also, frankly, people are avoiding the use of the technologies. Some of us are using flip phones occasionally because we can't be sure that our communications are safe, especially if we have sensitive communications. On the third question about an international regulatory framework, how do we get there? I mean, I think the goal would be to get a treaty. This is the ideal. We would have some form of collective, multilateral treaty regulating surveillance technology. I don't believe this is beyond the grasp of states. We have just concluded a cyber treaty, which was a very complex, long, technical, difficult negotiation. So I think it's possible to conclude a treaty. But I see zero political will by states to conclude a treaty right now. So what I think we get is piecemeal regulation. Maybe we'll get a country, maybe like Brazil, that will take a very advanced, important step towards defending the rights to privacy through the Constitution. I hope we will see Europe taking some measures. I think we will see a lot of litigation. There's a lot of litigation happening in many countries around this technology, and the litigation might force changes in practices. But I think it's going to be quite piecemeal, and I think the questioner is right that that's going to leave gaps in regions of the world where you can take a case about spyware. The government is going to continue to use spyware. Maybe finally to the first question, translator, I missed a lot of that question, so I wondered if you could give me a synopsis.
Vou pedir pro colega que fez a primeira pergunta fazer de novo. Aí ela consegue entender que você... acho que pode ser mais fácil. Tem mais alguém que quer fazer perguntas? Além do Paulo depois. Vamos fazer mais duas.
Oi, professora. Só estão fazendo uma resumida da pergunta. Foi basicamente se uma forma efetiva de regulamentação do uso de spyware seria impedir que esse tipo de ferramenta fosse desenvolvida por exemplo, empresas e evitar que esse tipo de ferramenta fosse produzida apenas por exemplo, organizações estatais. Aí ela poderia ser criada tendo em vista, com mais facilidade, a proteção também de direitos fundamentais, ou se tendo em vista que é justamente o Estado a entidade que utiliza essas ferramentas para lesar direitos fundamentais, se esse tipo de proibição ela seria inócua ou até mesmo pioraria a situação atual.
Obrigado. Vamos para mais uma pergunta. E daqui a pouco a gente também vamos se preparando para fazer as últimas perguntas, né? Por favor.
Primeiro agradecer a professora pelo Keynote, e explorando um pouco da pergunta do colega anterior, e puxando um pouco para o lado do meu lado, que é direito concorrencial, a gente tem visto uma série de dimensões regulatórias que em algum momento se chocam. Então, por exemplo, pedidos de acesso a dado da Apple, em que a Apple, durante a regulação europeia, defendeu que parte do monopólio dela lhe garantia que ela conseguia prestar alguma forma de regulação de privacidade melhor do que um mercado mais competitivo. Ou em casos como na Uber, em que fechar o API foi um mecanismo que a Uber utilizou para dizer que era uma garantia de segurança e privacidade. A minha dúvida, e tem até alguma discussão na Europa, nos Estados Unidos, por exemplo, sobre concentração no mercado bélico, concentração na produção de tecnologia, até que ponto ter 2 ou 3 firmas, que são as firmas que de fato têm capacidade de construção desse tipo de tecnologias, se esses conjuntos regulatórios estariam em relação ao outro indo de encontro em algum nível. Então, se a gente teria algum trade-off entre múltiplas esferas de regulação de direitos digitais, e que aqui a gente teria que talvez ter mecanismos de estratégia regulatória um pouco mais pensados um em conjunto ao outro. Assim. Me parece que no Brasil muitas vezes a gente faz isso muito separado, sem pensar na conjunção dessas esferas. Então, eu queria saber se a professora entende que tem esses trade-offs e como a gente poderia lidar com esses trade-offs nesse ambiente de várias dimensões regulatórias. E, de novo, muito obrigado pelo Keynote.
Temos mais alguma pergunta?
Yeah.
Então, professora, por favor.
Okay, I think these are my last 2 questions. So I would say, how do we, maybe one way to regulate is to prevent, right? And I think that's an interesting idea, but the truth is I think that's really, really hard to do. Much of the conversation we've had today is around commercial spyware. These are companies who develop, whether it's UK Gamma-based International or whether it's the Italy hacking team or there's US companies like Cyberpoint and Naros. These are private entities mostly who raise their money through venture capital underwriting. But what we haven't talked about at all is state capacity. And so parallel to all of this private commercial capacity are states like Russia, China, the United States, and others who have developed significant surveillance capacity that's not commercial, that they just use themselves, but have a really deep and profound relationship with the private sector in terms of the development and technology exchange. So there's both a private sector, privately available software development and state development. And these 2 things go hand in hand. I think it's almost impossible to think about outlawing or preventing state development. It's so ingrained in these state structures, it's just not going away. Is it possible that we narrow the universe of some of these actors? Yes, it is. Some of these actors, like particularly, I would say, there's several actors in this group who want to be, quote, good companies, sort of. They want to produce a terrible product, but they want to sort of play the game that they're responsible corporate actors. And we have a fundamental question as human rights advocates. Are we going to play with these people or not? And that, I think, remains an open question. On the final question about competition law is not my area. But I will say that these companies are in competition with one another. They're in profound competition with one another. And there's an interesting dialogue between these states about who are these companies, about who is the better company, who's more in compliance with international law than others, who's more open and to state regulation than others. So there are differences. Would competition law help us address the human rights challenges that we see with these companies? Of that, I am less sure, because competition law in general is not a body of law that's infused with human rights norms. And the fundamental challenge we face with commercial spyware is that it is profoundly abusive of human rights. So competition law might help make these companies more efficient vis-a-vis one another and regulate their market presence. But I don't think it's going to get at the fundamental problem that I have with these companies and this technology, which is that the product that they sell is abusive and is fundamentally undermining the rule of law and democracy across the globe. So, thank you.
Muito obrigado, professora. Com isso, eu lhe pergunto se você tem comentários finais a fazer.
No, many thanks for joining you, and I hope there's a really good Supreme Court decision and that you'll tell me about it.
Nós também esperamos. Peço uma salva de palmas, professora. Muito obrigado. Vamos lá, vamos andar com o nosso programa. Agora, nós adiantamos para 7h30 o nosso coquetel de lançamento deste livro rosa que está nas minhas mãos. Antes de convidá-las e convidá-los para o coquetel que vai se realizar, como eu já disse, nesse mesmo andar, na Sala Visconde São Leopoldo, só vou falar só algumas palavras sobre o livro, perguntar se a professora também, se quiser falar. Ele, segue o padrão dos últimos livros do Congresso que realizamos. Tem, enfim, o tema do spyware, por exemplo, está presente. A gente, o amicus curiae que a professora mencionou está resumido no final, no último artigo do livro, então, para quem tiver curiosidade para conferir. Também uma discussão que aparece bastante no livro, foi uma discussão que tivemos no Congresso passado sobre essas tecnologias de monitoramento e câmeras de segurança que estão espalhadas pela cidade,
né?
Segurança privada. É um tema que aparece bastante nesse livro e tem também um artigo da equipe do InternetLab que ficou excelente. Mas também, enfim, outros temas, tema da reforma do Código de Processo Penal, por exemplo. E aí, alguns aqui vão perguntar, mas como é que eu adquiro o livro, né? O livro é gratuito para ser baixado na internet, né, em PDF, mas a via física que temos aqui, ela é brinde para quem fizer uma doação ao InternetLab. Como vocês devem saber, o InternetLab é uma organização sem fins lucrativos, então essas aqui físicas ficam para aqueles que apoiarem o nosso trabalho, mas claro, o conteúdo é disponível para todo mundo na via digital, tá bom? E aí, enfim, isso aí pode ser resolvido lá fora na mesinha que temos. Com isso, convido todas e todos. André, alguma coisa?
Lembrete de devolver o...
Lembrete, devolver os fones de ouvido da tradução. Todos que estão devidamente com crachás sabem da programação que temos amanhã, mas eu não vou deixar de lembrá-las e lembrá-los. Amanhã nós temos 4 mesas, é o dia mais cheio do nosso congresso. A gente começa com uma mesa na parte da manhã sobre monitoramento em fontes abertas. Então, toda aquela discussão sobre raspagem de dados em redes sociais e como isso alimenta as possíveis investigações. Às 11, uma mesa sobre inteligência artificial, vigilância de dados e justiça criminal. Então, aqueles que querem embarcar no hype da inteligência artificial terão essa mesa. Tô brincando, mas enfim, acho que vai ser uma mesa super interessante. Esse tema da inteligência artificial já aparece nas últimas edições do Congresso. E na parte da noite, uma mesa sobre legalidade e meios de obtenção de provas digitais e a nossa mesa sobre a regulação de cybercrime internacional, que acho que vai ser uma mesa bastante interessante. A gente vai ter a presença e a fala do diplomata brasileiro que participou diretamente da negociação desse tratado, então acho que vai ser bem legal. E no na sexta-feira, nós temos a nossa mesa redonda sobre esse caso do Supremo, que a professora mencionou, que vai ser uma mesa bem maior, né? As mesas redondas, elas são com mais convidados, as falas são um pouco menores para privilegiar a interação. Vamos discutir esse caso do Supremo, da DPF 1143, e encerraremos com a presença da secretária de Direitos Digitais do Ministério da Justiça, a doutora Lilian Sintra de Mello, que vai terminar o nosso congresso conosco. Tá bom? Vamos lá para o nosso coquetel de lançamento. Obrigado pela presença de todo mundo e até o outro lado do andar.